Welcome to Packet 1. This packet that we're going to go over is required for all the people that are filing for divorce in the state of Florida, whether you have property, children, or no property or no children. And these are the forms that are required by statute. And they're basically general forms to let the court know of the different status that you're in, i.e. whether you're residing in Florida for at least 6 months, if there's any other cases that are involved, also regarding your financial situation. These are all the forms that are required, and you cannot initiate divorce without these forms. And so we'll go over the forms, and if you look at the forms, you will see that there is the first page, which includes the list of all the forms that are required. And it starts with Dissolution of Marriage Forms Packet 1, General List for all petitioners. And if you look at the form list, you will see that there are several forms. And this would be one of the biggest packets that we have, only because it is required by law. And just briefly, I will go over the forms we have, which is the application for civil indigent status, the summons, which we discussed about filling out, process service memorandum, notice of related cases, cover sheet, notice of social security number, notice of confidential information, affidavit of military service, and or you have to file either a copy of your driver's license or affidavit of corroborating witness. There's also family law financial affidavit, certificate of compliance, and the final disposition form. And we will go over each form more thoroughly. So the first form that you have is the application for determination of civil indigent. And the reason why this form is important is because it allows you to get some benefits. And what it is if you qualify for the workshop through Community Legal Services, you are qualified as an indigent status. And indigent status is for those that have low income or fall under some type of income restriction about right above the poverty line. And the purpose of this is so that you have access to the courts and allows you to have some benefits. One of the most important benefit is if you qualify, they will waive your filing fees. And what that means is you do not have to pay the filing fees. And the filing fees are almost $500. So it will be a great benefit that you would have if you qualified as an indigent. And as I mentioned, the fact that you qualify for the workshop and to services of Community Legal Services, you should be able to be determined indigent. And we will just go over the form briefly. If you look at the form, there's what we call the title, case style, and I'm highlighting it. This is just what all the forms that are filed in your case will list. And it says in the circuit court or / county court, and divorce is always in the circuit court. So just be aware it will be circuit court of the blank judicial circuit and then for blank county. And what the judicial circuit is, the circuit where you'll be filing your divorce, same as where the county is. And it depends on which circuit you are. If you are in Orange, Osceola, you're in the 9th Judicial Circuit. If you're in Volusia, you're in the 7th. If you're in Marion, Sumter, Lake County, Citrus County, that's the 5th Circuit. And if you're in Brevard and Seminole, that is considered the 18th Circuit. So double check with the court that you'll be filing your case with. And as it says plaintiff / petitioner or in the interest of. When you file for divorce, you as the person seeking the divorce is considered the petitioner. So you will be the petitioner. The respondent is the person you're seeking the divorce from. So what you would have to do is write your full legal name and write the person you're seeking for his full legal name. And the case number will be left blank because it has not been assigned. Once your case is filed with the court, the clerk of court will assign the case number. And as the title suggests, it's the application for determination of civil indigent status. And it says, if you qualify, your filing and summons fees are waived, but other fees might not be waived, just to be aware. And so we'll go over each of the form. And there's some counties, they charge you to file the full application. So just be aware, and it's about $25 and it's a non-refundable fee. So number 1 says how many dependents you have. These are the dependents that you're financially liable for. Usually children under the 18, you're financially legally required. Otherwise they're not, or if they're disabled. So you will list them. If you have 2 kids, you'll have 2, and if you're yourself, there'll be 3. And then it asks you, are you married? And at this time, you're still married. And then it asks, does your spouse work? Yes or no. And if you know your spouse's income, if you don't know, you just write unknown. It doesn't have to be exact to the penny. You just have to make sure you get at least a rough estimate. If you don't know, you're gonna write unknown. And then this number 2 is regarding your income. And as it says, it's net income, which means income after taxes. And you have to write how much that is and whether you get paid every week, every other week, semi-week, monthly, or either. And if you have other, then you write other. So you have to, and it explains what your income is. Number 3 asks whether you have other income. And this includes second job, Social Security, unemployment, union, veterans. If you don't have any, you're just no. You could just do one no and just straight line. You don't have to circle each of the no's. And then next, you're going to list whether you have any other assets. That's whether you have a cash on hand, bank accounts, any CD, boats, savings. You would have to write the rough estimate. You don't have to have a penny, but you have to do the penny, but you have to write it. And if you don't have it, just circle no, and same thing. And then check 1. This asks you, are you expecting to receive any money in the future? If you don't, you're not. If you do, you have to write how much you expect. That is if you have some money coming to you that you're expecting, like if you have won a lawsuit, you're going to get a payout, etc. That's what you would list. And then you have any liability. These are debts that you have. And it lists anything, like if you have a loan in your vehicle, if you have a mortgage, if you loan on the boat, any type of property you have that has a loan. If you're paying child support, that's what you would do. If you're not paying child support, if you're receiving child support, that's not a liability. So any credit card debts, any medical bill, any recurring debts that you have, and anything else. If you have a student loan, etc., you would write all that. This is just to let the court know whether you can afford to hire an attorney. So you have to write all that information. And number 6 asks whether you have a private lawyer. If you're filling this form out, you don't have a private lawyer, so you will be checking no. And just to let you know, what you have to do is, once you fill out all that information, you have to take it to the clerk of court, and they will look at information and let you know. And what you have to do is you have to provide a copy of your driver's license or a state ID, and they will check it to make sure you're the person filling it out. And then they'll tell you right then and there whether you are indigent or you're not indigent. So if you're determined to be indigent, you don't have to pay your filing fee. But if you're not indigent, they expect you to have your filing fee with you when you're filing your divorce. Okay? All right, the next form you have is a summons. And the pages I'm going to scroll over is just brief introduction that they have. And it's basically, I'm going over it shortened. But if you want to go back and look at it, you always have a right to go back and look at it. And that's what we provided for you. Okay, so this is the form. And as I mentioned earlier, you're going to write the circuit that you're in, what county you're filing, what case number you have. Again, you're going to leave it blank because you don't know. And you will leave the division blank too because the court will assign it. You're the petitioner and your soon-to-be ex is the respondent. So that's where you'll write it. So when you fill this summons out, you're going to be writing the person that you're trying to serve, which is your spouse, and their address you have. If you don't have an address, you don't have to use this form. But if you do have an address, you could use it. What I would recommend is if they're staying with a relative, if they have a cousin, or if they have a friend that they're staying with, wherever you think that they will be able to be served these legal documents, that's the address you want to use. Because on the title, it says summons, personal service on an individual. All right. And then second part says important, the lawsuit has been filed against you, the respondent, and they have 20 calendar days once they receive the summons to file a response to the clerk. And what you have to do is you have to make sure you look up the clerk of court in whichever county that you are, and write their mailing address so that they have to file a written response to the mailing address. And then next, they have to send you a copy of the mail response that they file. So you're going to say, if you do not file a written response, you may lose the case. If you choose to file a response, you also have to send it to you. So this is where you will write your name and your address. So make sure you include that because they also have to send you a copy. All right. And the next section is in Spanish and in Creole. So if you need someone that doesn't speak English, you could use that. In this section, you're going to leave blank because what it is the clerk of court, when they issue the summons, will sign and stamp it and date it because their seal or their stamp becomes official legal document, and the sheriff and the process server has the authority to serve this legal documents. And once the person receives it, that means they're on notice that the lawsuit is started. And the next form is the process server memorandum. This is just a form that you fill out so that person or the persons that are serving these forms know who to serve and how to serve them. So these are the instructions. So you could, I'm just going to skip through that and see, it's just for the process service memorandum to the sheriff or the process server so that they know what to do. And you're going to fill out the top as usual. And then you're going to do 2, the sheriff of the county where your spouse lives. So you have to know which county they're residing. If they're in Orange, Seminole, Lake, Osceola, you have to know the county. And then which division is civil division. So what the service of the servers for divorce is civil. And if you hire a private process server, you'll write their name there. Normally, I would say using a sheriff's office is more economical, but you always have a right to choose a process server. And the process server, you could get a list of them through the clerk of court. They keep a copy of all the process servers that are authorized to serve, because they also have to be authorized by law to serve the legal document. And then it says, please serve the name of document. So we'll go over more of the forms that you need when you're filing, but this is important because you have to have at least a petition for dissolution of marriage, the financial affidavit, notice of social security number, and the certificate of mandatory disclosure. Those have to be personally served. So you have to write those at least. And then the party is you're going to write the person that you want served, your soon-to-be ex, and their address. You could also provide a second address if you have, but that's only if you have a second address. And you also have to let them know if they have guns, because this is for the protection of the sheriff and or the process server, so that they know that whether they need to be more careful. And then there's any other special instructions that you have. Let's say their house is in a dirt road down the street. You could say dirt road, first house after, etc., so that the process server knows where to go. And this one you can sign and print your name and the address. Okay. And so this is just for brief. You're going to see a lot of these forms with if a non-lawyer helped you fill out this form. At this point, you're leaving all this blank only because you're the only one filling out the form. No one is helping you. However, if you later choose to hire someone like a paralegal or some type of services, they will fill this form out for you. And the next form is notice of related cases. And this is a form that you need to file just to let the court know whether there's any cases. Usually if there's an injunction case, if there's a Department of Children and Families case, or if they have a case involving in criminal case where you're a victim or he's a victim, things like that. You want to let the court know. And the reason why they do that is because so that you don't have conflicting orders. You don't want one judge to say have no contact and the next judge is like, no, you could have contact with the kids, etc. So you're letting the court know whether they need to be consolidated and or maybe work together to resolve the cases. The form that you fill out, the top is the same. And what we're going to do is you're going to fill out the notice of related cases. And this lists why it's required. And it briefly explains the type of cases that you want the court to know, i.e. like if there's a violence injunction. If you don't have any, you don't have any. If you do, you want to click that and you're gonna write the case number, who the petitioner, respondent, and the type of case that it involves. It all includes child custody, child support, dependency, termination of parental rights, injunction. So you would have to write that. And there's a space for other cases if you have. If you don't have any, again, check no and you're done. So there's several areas that you could fill out. And if you did have cases that were related, you could say you want a coordination, meaning you want the one judge to coordinate with the other judge. You could do that, or you could have it assigned to one judge. In a lot of courts, they're doing the unified family court where you have one judge hear all the cases involving the one family. So they might do it anyway, but it gives you an option whether you want to or not. And so this one you have to sign and you could serve. All right, so the next form we have is the cover sheet. All right, so this form has the cover sheet, and the case style, as we mentioned, is the circuit. You're gonna fill out as you did in the other forms. And this one is pretty simple. Everything that you're filing is an initial action, so you're gonna check that. And everything you're filing is check B, dissolution of marriage. This is not simplified. This simplified we'll go over later if you have no property, no children. But at this time, everyone is filing a dissolution of marriage. And the purpose of this is just to keep track of what type of case is being filed. And it helps the court so that they know how to divide the cases. And if you did have a related case, the form we filled out just before, you're going to write, yes, we have related. If you don't, you're going to write no. And although it says attorney or party, you could sign, you got to print your name. You don't leave that blank. And I would include an email address only because the courts are now doing a lot of e-filing or sending orders, notices through email. So they need an email address and it's a lot quicker. And then you date it when you file it. And you're going to leave that blank. All right. Next. This is a notice of Social Security number. And this is just required in the state of Florida to make sure that you are a resident and or citizen of the United States that have a Social Security number. You don't have to be a citizen if you have a Social Security number, so that's fine. And just to let you know, the information that you are writing in here will be kept confidential. And once you file it, your Social Security and date of birth will be redacted in black. So if anyone else sees it, they wouldn't be able to see that number. It's only for the purposes of records. So that's why they need it. So you're going to keep the top the same as you did before. You're going to write your full legal name, your Social Security number, and your date of birth. Again, it'll be kept confidential. So, and you're going to, if you have children, if you don't have children, I mean, you're going to check one and then you don't have to fill out any more. If you do have children, you're going to fill out, you're going to check here and do a line for each child. So you're going to write the name, and at this point you don't have to write their full Social Security number. All you have to do is their last four digits of the Social Security number. That's all the court needs. And then you could, this form, you will see you need to notarize. And there are several forms that we'll be going over that needs to be notarized. And it has this section here. So once you fill this out, do not sign it because you will have to sign it in front of a notary. And this next form is notice of confidential information. Because the form you just filled out, the notice of Social Security number, involves confidential information such as your Social Security number and your date of birth, you want the court to know those are information that cannot be released to the general public. In Florida, we have open courts, so a lot of forms or a lot of case files are available for the public to view. However, if there's confidential information, they will be one, redacted or sealed so that no one else could see it. So you want the court to know, hey, I don't want anyone else seeing my Social Security number and my date of birth. So you could get that. And you're letting the clerk know that you're filing it. So you're going to fill out the top the same. And you're going to fill out, I am filling out this form, and the entire document is confidential. And the document is the notice of Social Security number. Okay, this is just a notice letting them know there's confidential information you're filing. And you fill out this one, you don't have to notarize, you can sign and date. Next form is affidavit of military service. This form is important for people that have spouses or you yourself if you're in the military. It's provide notice to the courts because under the federal statute, if you're in the active duty military, you have some protections. And one of the such protection is if there's any lawsuits that are filed, it may be put on hold or what we call stay. However, you could waive that and say, I know I'm in the military, but I'm okay with going through with the lawsuit. But you have to let the court know whether anyone is in the military. And you'll fill out the top the same. And you, as the person filing it, you're going to write your name. And if they're in the military and you know for sure, you're going to check 1. If they're not, you're going to check 2. And if they're in the military and you try to find out and you don't know, then you're going to write why you don't know and what happened. Okay, and this one has to be notarized. Just a brief information purposes. Anything that says affidavit on top, you have to get notarized, and it's very important that you understand the purpose when you're filing an affidavit. Affidavit is as if you're swearing under oath when someone is when the judge is questioning you in person. So when you're signing this form, you will see that this is what it is. Say, I understand that I am swearing or affirming under oath to truthfulness of this claim and punishment for knowingly making a false statement. Basically, what it says is that I'm telling the truth. If I'm lying, I could get fined and or go to jail for contempt or for perjury or lying under oath. That's what it is. So when you sign this form in front of the notary, you're saying, I swear to tell the truth. So just understand that. And a lot of times people, that's what they get in trouble with the courts is because if they lied when they said, oh, I'm telling the truth, and later the court finds out you lied about it, then that you could get a fine and or go be held in contempt and go to jail. Okay, so the next form. There are 2 forms that deal with whether you could prove that you've been a resident of the state of Florida. To file divorce in the state of Florida, you have to be resident for at least 6 months. What that means is prior to filing, you have to have lived in Florida for 6 months. So if you just moved here a month ago, you have to wait 5 months before you could file a divorce. However, if you've been here a year, you could file a divorce in the state of Florida. So this is showing proof how you could do it. There's 2 ways. One way is by filing a copy of your driver's license, which is saying, hey, I've been a resident. Make sure that the form or your driver's license or your state ID, you could use either one. Make sure that those are within 6 months. So the date that you got the ID has to be within 6 months. So if you renewed your ID last week, you can't use it. So you have to make sure that you have proof that another way of proof that you've been a state of resident. And that way you could do is the next form, affidavit of corroborating witness. What this form is basically, you're going to ask someone you know that you've known for at least 6 months, and they're like, hey, I know Jane, she's been living in Florida for over 6 months. So you're going to have them fill this form out. So that person, it could be your neighbor, your friend, your grandma, your cousin, anyone that knows that you've been in Florida for over 6 months, they're going to say, my name is Jane Doe. I know Janice has lived in the state of Florida since June 2001 and have stayed here until then, which is more than 6 months. They have to sign and get it notarized. And again, they're saying, I swear to tell the truth that I know that they've been in the state of Florida for more than 6 months. That's all it is. It's one or the other. So if you have an ID, you don't have to do this form. If you don't have an ID, then you would have to do this form. You don't have to do both. The next form is the financial affidavit. And this is the most important form, just to let you know. I know a lot of people have financial situations that are very difficult to explain, but you need to fill this out truthfully. And again, as I mentioned earlier, when you were doing the affidavit of indigent, you don't have to have it exact to the penny, but you have to have it reasonable. So if you make, $6,700 a month, $755 a month, you have to make sure you could round it out. You could say 6,700. So it doesn't have to be to the penny, but You have to be prepared to prove it if someone challenges it. So if you file this affidavit and your spouse is like, no, I know she makes more than $500 a month, then you have to prove it by showing your pay stub, your bank statement. But we'll go over that later when we do the certificate of mandatory disclosure. So this is one of the more important forms. And this is the form where a lot of people get in trouble because people tend to lie about their financial situation. So it happens. But I always tell people you have to be honest. The judge doesn't care how little money you have. He really doesn't. He just wants to know your situation because this is what is used to determine child support and alimony and any type of asset division if you have equitable division of property. So this is very important and you need to tell the truth. And it doesn't have to be to the exact penny, but you have to be reasonable. And I always tell people, you don't have to, if you think you're like, oh, I don't know what my salary is right now as I fill it out, go check out your pay stub because that will have a more accurate amount. Okay. So we'll go over this. So you're going to write your full legal name and your occupation and where you're employed. If you're unemployed, just write unemployed and your pay rate is 0. And if you have your business address, you could write it. Or if you want it confidential, just write confidential. And you're going to write your pay rate, how you get paid. You get paid every week, every other week, twice a month, monthly, other. Also, if you're unemployed, you have to check there and you have to explain why you're unemployed. If you have space, you could write it there. If not, you could write it on a separate piece of paper. Say, I've been unemployed since COVID. I have not been able to find full-time employment, or I'm in between jobs. Again, the judge doesn't care unless you lie about it. So just make sure you list that to the judge for the judge to know. Okay. So now we're going to do section 1, your present monthly gross income. Remember when we were doing the affidavit of indigent, you had to do the net income? Gross income is your income before taxes. So you're going to write your gross income. So if you get your pay stub, it will show you all your salary before all your taxes are taken out. So you're going to write your monthly gross income, any bonuses you have, any other disability that you may receive, or unemployment. So maybe you don't have a salary, you only get workman's comp or unemployment. This is where you're going to write it. Or if you're receiving alimony, you're going to write where you're receiving alimony. That's only if you're receiving it. So you're going to fill out any other income you have. If you have rental, any interest or dividends that you're getting from stock, any type of royalties, any, dealing in property, or any recurring income. That's where you're going to write it. And once you add all that up, you're going to write the total on number 17. So that's your gross income. So next is your monthly deduction. This I would definitely recommend looking at your pay stub because you can't know how much is deducted. So you'd have to write your monthly deductions that you get, any Medicare payments, FICA or self-employment, any retirement payments, anything that's deducted from your salary, you're going to write. Or if you're paying child support, you're going to write that. Or if you're paying alimony, you're going to write it. So once you get all that, you're going to total your deductions. So you have your gross income, your deduction, and what you do is you take the deduction, subtract it from your total gross, and then you get your net. Your net is important because that's what you need in the next section. So you get to the next section. Section after this, I'm sorry. So you get section 2 is your average expenses. So these are all your expenses that are recurring. Also, it might not be a recurring expense, but you need to figure out how to determine whether it's an average. So you may know how much you pay on mortgage or rent, your telephone, your utilities. However, your food, meals outside, and maintenance is not always exact. So you might get groceries every week, or every other week, or once a month. I don't know how you do it. So you have to write your average monthly. So if you spend $100 a week, or $100 every 2 weeks, let's say, so you're spending $200. So you have to do 200 times 12 divided by 12. So then that's how you get your average monthly. Same thing with meal outside. Okay, let's say meals outside. You don't go out every month. but you have to have a rough estimate of how much you spend. So if you go out, you spend $200 this month, but you didn't spend any for the next 3 months. So let's say you go out every other month. So that's 6 months. Let's say you go out once every other month. So for 6 months, you spend $100. So that's $600, and then you're going to divide it by 12 to get a rough idea. Again, it doesn't have to be exact to the penny, but just a rough idea. If you don't eat out, great, you write 0. Same thing with any other maintenance or repair. Gasoline, same thing. You might not go drive every week, and so you might not fill up your gas every week. So you just have a rough estimate. Same thing with the repairs. You might not repair your car every year or every month, but if you do it once a year, what you do, so if you spent $1,000 last year, you're going to divide the 1,000 by 12, and you come up with a repair monthly. Insurance, you should know, it should be the same. And if you have any children, you're going to write their expenses, like any daycare, that's regular. If you give them lunch money. And this is another thing: clothing, grooming, and gifts for the holiday. Again, those it's not a recurring monthly payment. So you have to take what you normally spend in a year, divided by 12, and that's how you get a regular monthly. Same thing with any other expenses that, maybe you pay for them to play extracurricular activity. It may not be monthly, but you have to have a rough estimate of how much you're gonna do. Say you should know how much you pay for all your insurances. And then this is for yourself. So you have any clothing you buy for yourself, any grooming, entertainment, gifts, any other deductions you might make. Again, this is monthly. So if you don't get your hair cut every month. Some people do, but some people don't. So you want to average it out for a year, how much you would spend in a month. And creditors, these are where you're going to list all your debts that you have. You have any type of credit card debts, student loan, you have doctor's bills, you took out a personal loan, you're going to write in the monthly expenses that you have towards it. So you're going to take all the monthly expenses and you're going to add it to the total number 28. So you're going to take your expenses there. You got to write that. So you had your net income from line 27, then your expenses. You deduct your expenses from your income, and then you'll either have a surplus. If you have money left over, it's a surplus. If you owe money afterwards, then it's a deficit. Again, the judge doesn't care how little money you have or how much money you have, but you have to tell the truth. So you want to let the judge know about that. Okay. The next section is the assets and liabilities. The assets are everything you own, and this own of value. And there are two types of assets. One is marital and one is non-marital. So non-marital assets are all the assets you owned before you got married. And there's some assets that you owned before you got married that can be converted to marital assets, but we'll go over that a little bit more when we go into each of the things. And then marital assets are anything you bought after you got married. So you got married May 1st, on May 3rd, you buy a house. Even though it's in your name only, it becomes a marital asset. So you have to list it as a marital asset. So let's say you got, while you were married, you got an inheritance when your grandma died. That is considered a non-marital asset. So you have to list that. Or let's say you had a house, you bought a house on, 10 years ago. That's yours. That is considered non-marital. However, if you lived after you got married, you lived in it together, you paid mortgage together using marital assets, i.e. your salary and her salary, and you improved it, it may convert certain part of it into marital assets. Just be aware of that, okay? So these are the type of assets you have to list. There's other spaces you could list. So cash on hand, whatever you have in your pocket right now, any cash in your bank account, any stocks and bond. Again, if you had stocks before you got married, that should not convert from non-marital marital. But again, if you bought more while you were married, there's some parts of it that may be considered marital assets. So just be aware of that. Real estate home. We were just talking about it. So you bought a home and It asks for current market value, so it doesn't have to be the exact amount how you think how much it works, but a reasonable amount. So if you have a house in Lake Mary with a lake view and a pool, and you write it's only worth $100,000, it may not be the fair market value. So just be aware of that. And then on the other, like if you own a second home and you automobiles that you own, the current market value, even though you have a mortgage and a loan on it, you have to write the actual value of it because the liability section, the loan section will be listed separately. Okay. And so then it asks for any type of retirement plan. If you have an IRA, 401k, if you had it before the marriage, it's considered non-marital. However, if you contributed towards it while you were married, it may convert to marital, just that portion of it. So your situation is different. So you may have to look into it through your company. And then any other assets do you have, you're going to list it. And then you could write marital and non-marital. A lot of people list like furniture, if they have a furniture, if they have a boat, if they have, you know, tiny home and anything like that, you could list it and the fair market value. And then you have to add the total and list whether it's non-marital only. If it's marital, you don't check it. If it's non-marital, you check who is non-marital asset for. All right. And the next section is liabilities. Just like you have marital assets, there's also marital liabilities. Similarly, if you accrued debt while you were married, it's considered marital liability. Or if you accrued debt before you were married, then that's considered non-marital liability. Just like you divide assets, you can also divide liability. So mortgage, you listed the house's asset, now you're going to list it as a liability. How much you owe, if there's a second mortgage, any other mortgage, if there's a loan, any credit card accounts or debt that you accrued during the marriage or before the marriage, you're going to list it. Or if you have student loan, medical bills, etc., you're going to list all the liabilities and add the total. Next section is the contingent assets and liability. Contingent assets and liabilities are those assets that have the potential to become assets or potential to become liability. The example I use is, let's say you were in a car accident and it was you got hit and you're suing the other car driver right now, but you don't know how much you have. You don't know how much you're going to win. So you're going to write possible value, but you don't, something has to happen before you get it, but it's possible. Doesn't mean it's going to happen, but you have to list it, because same thing like you divide assets and liabilities, you're also going to divide contingent. So if you got into the accident while you were married and then you get the money after you get divorced, you may, I say you may have to divide it. Same thing with liabilities. You were driving the vehicle, you hit someone, and you may have to pay $100,000. You haven't lost it yet, but you may lose it. So you have to list it. Same thing. If the accident was made during the marriage, it may be a liability that you have to divide. So you just have to let the court know about it. All right. Next section is for child support. This is only for people that have minor children under the age of 18 or 19 if they're still in school, and or people with children with disabilities. You have to do a child support guidelines worksheet. If you already have a child support case through a separate court, you don't have to do it. So you will check no. If you don't, and you're asking for child support for first time through the divorce, you have to check yes. And if you don't have children, you're going to check no. Okay. And this form, you have to sign it and make sure you get it provided to the other party. Next form. This next form is certificate of compliance with mandatory disclosure. This form is just letting the court know, hey, I'm going to be responsible, and send them all the forms that I'm required to do by law. And this is just regarding your financial situation. Remember I said that financial affidavit is one of the more important forms? This is also important because you're saying, I'm required to release all these forms, and I know I'm required to release all these forms, so I'm sending you this form. Just beware, this is just saying to the court, I'm gonna follow the law and provide the forms that he wants. And at this time, when you're first filing, all you're required to do is send a financial affidavit. That's all you require. Every other form, you don't have to provide it unless they ask. So I'll go over the type of form. So you're gonna fill out the top as usual. Then you're gonna write your name. And there's two sections. One is temporary financial relief, and the next one is gonna be the initial and supplemental. So there's a difference. So the temporary is for any type of relief that you're seeking while the divorce is pending. Child support, alimony, those are the two financial. So if you're wanting the court to pay you temporary child support or temporary alimony while the divorce is pending, this is the section you will have to fill out. So you're going to leave that blank, and you're going to fill out, you're going to provide the family law financial affidavit and the short form, because that's the form you filled out. These are not required at this time. This is only if the other party asks you. What they will do is, if they want these forms, like the state and income tax, any type of W-2, 1099, only if they request it through demand for discovery, then you have to provide it. But at this point, when you're initially filing the divorce, you don't have to fill out those forms. Okay? So that's for temporary. So the next section is for initial, supplemental, and permanent. So when you're filing your divorce and you're saying, I want him to pay me child support for the first time or alimony for the first time, this is the section you're going to fill out. And again, same thing, you're going to fill out A and short form. All these other forms, like, again, 1099, pay stub, source of income for 6 months, financial statements, all those forms may be required, but not at this time. What the court will do is later, if the other party's like, I know you're hiding money from me, I want you to send me your checking account, all the statements from your checking account, any type of CDs that you have, I want all of that, IRA, pension. They have to make what's called a demand for discovery. Then what would happen is they will do the demand for discovery, you will get all the forms, and you will fill out another certificate of disclosure, and you will check it. So I'm giving him the past 6 month IRA. I'm going to give him any type of, money that you might have in Bitcoin, any type of information, health insurance, your brokerage account, checking account. You have to provide it. And just like you have to provide it, if you want some information from your spouse that you think might be hiding, you could do the same thing, a demand for discovery, and then ask the court to send you all, make him give you all these forms. Same thing like credit card accounts. So these are all the type of forms that you could be required to provide, same as you could order the other party to provide to you. So you're gonna sign all this paperwork. And the last form we have is the final disposition form. Just like you had to fill out the first form regarding the cover sheet, this is the final disposition. And what will happen is this, although you're filling it out now, the form will not be completed until the divorce is finalized. And this is just for statistical purposes to see how the case is resolved. So at this point, all you're going to do is fill out the top and the bottom. This middle part will be filled out by the court, because the court is going to decide what happened to the court. How was it disposed? Was it dismissed? So this section is going to be left blank. Okay? And all you have to do is sign it. And you're leaving that part blank. So those are all the forms that are required for packet 1. And then we will do packet 2 next.